Hi guys, it's Kathy. I hope you're doing well. I hope you are nowhere near a wildfire. Oh gosh. And I hope you guys are nice and warm or cool, depending on where you are right now. And I hope one of you has a good day somehow. Just go into Discord whenever you need to. So, Fozzie, I tried to do what you told me to do. I tried to make a video while I was at work since I didn't have time to do it while I was here because I was sleeping. And it didn't go well. But it went well enough that I'm going to play it here. Just not well enough to make it a video. I don't even know if you're going to hear it. So I go into this back room at work. It's an event room that we hold parties in. And, you know, I tell everybody I am going to make a video. I'm going to make a video in that room. So of course, that's when they come in. And the other server has a whole conversation with me. And it was hilarious. I was laughing the whole time. So I don't know if we're going to hear the conversation. I hope we do. Because this is what happens when I try to do something. When I need a little private time, I should have done it in the bathroom. I should have made my video in the bathroom. But no, I would never take you guys into the bathroom. Never. Bonjour. Thank you. Okay, but we're going to start nice and easy. We're going to start with some cousins who are mad at each other. Let's start there. This cousin, I know it was you, is mad at this cousin. And this cousin is on her pillow and has her blankie for court.
Proceed with your defense.
There's not a defense. I am not denying that I owe the 15 or the 25. There's no defense. It's just the extra amounts that they're adding on that I do not agree with. I borrowed the money from her. I asked her for it. She sold me 1,500 for in July, and then the other in August. I'm wholeheartedly not denying that I owe her. However, she asked me in September when I was going to be paying her. I told her, she said some or all of the money. And I told her it would be in 2 weeks, which I did send her 300. And then 2 weeks later, she filed this case. So this is where we're at right now.
Drops mic.
Okay. Anything else?
No, ma'am.
Anything else, Miss Archie? Or do you have cross-examination questions for her at
I
this time?
do, because when you ask about the funds, when we did the preliminary or whatever that was, she said she didn't owe me anything over the 1,500. And so I would like to know.
Your Honor, that's not true. I so heartily said I owed both of them. I did not.
All right, so we've gotten that clarification. Here's where we are today, is that she admits to 1,500 plus 26, 25, 15. She has said that she disputes the interest that has accumulated on the 26, 25, 15. What is your question, Miss Archie, to her?
The question is, why would she not owe the interest when it's her venue sitting on my card with no payment?
All right, you've asked the question. Hold on. What is the response, Ms. Hogue?
I don't owe interest. I didn't say anything about paying interest. I asked for what I asked for. And had you not taken it to court, that would have already been taken care of. But since you want to play these games, this is why we're here.
Next question. She disputes she owes interest. Next question.
And why would she not owe the 200 in interest that she offered in her own
So let her answer that question.
The 200 in interest. I said that as well. I owned up to that as well. So I'm not sure what you're arguing about because I've said what I owe, but I'm not paying what I did borrow. I
Okay,
did the
so the next
1,500,
question is,
26, and then I said the 200, which I've paid 300 of that. Had this not been here, it would have already been taken care of and paid for. But she's playing games.
okay, all right, Ms. Hogue, you've answered the question. Next question, Ms. Archie.
Fozzie, you'd never have to pay interest on a credit card or home loan if you don't pay the home loan or the credit card. There, you learned something.
When someone puts something on a card, no matter whom it is, that interest of what is on there should be paid by the person that funds went to. Is that not correct?
That's a statement, not a question.
That's the question. If it was on
That's not a question, that's a
So
statement.
again, I will make the determination as to whether or not it's a question, Ms. Hogue. Please put yourself back on camera. So the question is, if you make, let me rephrase the question, Ms. Archie. Again, Ms. Hogue, I cannot see you.
It's sliding. My apologies, Judge.
So the question, Ms. Hogue, is, and you just, there you go. Thank you. The question is, if the card was used that accumulates interest, why would you not owe the interest to? We can't hear you. You're on mute. Go
Because I
ahead.
didn't put it on the card. She put it on the card. That was her choice to do that, not mine.
it was
All
your,
right.
your
So again, it's not an argument. Just ask the question, Ms. Archie. Do you have another question?
the question is, why would you not pay for your venue for someone to have to put it on their card?
And again, I borrowed it. You offered it. I borrowed it. That's what it is.
So,
Don't shake your
okay,
head.
you answered the question. Everyone, this will go a lot smoother if we just stick to the question and the answer without a lot of additional emotion to it. I understand that you all are family and that this is emotional for you. However, I just need for you to ask the question, answer the question, and I get that there's a dispute. That's where I come in. So, Ms. Archie, are there any other questions that are no longer on interest because she disputes it? So that means the decision is left to me.
The interest for as far as she can dispute it, Judge, and I'm fine with that. I think that's normal. But I think that we all know that when you put something on a credit card because of your inconsistencies or failures to do something.
But you're asking questions. You're not giving me a statement right now.
The last question that I have is, why would you wait 2 weeks to call me before I even filed something of this nature when I tried to speak to you in concerns to it?
Because you were too busy running around telling Nene and everybody else my business instead of being a grown woman and coming to me like a woman. So that is why we are no longer.
Oh, I'm not muted. So wait. So she's not the grown woman. You're the grown woman, but she's not the grown woman because you borrowed money and then she told people that you borrowed money and you don't want to pay back with the interest, but she's got it.
Communicating. I paid what I paid. You did what you did, and this is where we are. There's nothing else that we need
You
to
answered the question.
Why was your
Next question.
for me too? So I could not speak to you.
Girl, you had a number because you texted me on it. So quit acting like you ain't had no number.
Okay, answered that question. Next question.
Judge, as you will see in my actual part 18, her number was changed to something totally different, and that's in there as well. So
The court will make a determination.
Regardless of whose number it is, it's still my number. And it's a number for you to
Ms.
contact me
Hogue,
on.
stop it. I don't want to hold anyone in contempt that would require further sanctions for either side. I just ask the question and answer the question. And let me just say this to you, Ms. Archie, with all due respect, some of the questions that are being asked are really issues for, number one, you all to resolve as a family. But number two, she's made an admission to the amount that is due and owing at principal. It will be within my discretion to determine if there's any additional amount that is awarded beyond that principal That would be what your request is for the interest that has accumulated, okay?
I agree.
All right, so if there's no other questions, we really already have the baseline of the principal amount of the judgment, and what's left to my discretion is the issue of interest that you are seeking.
I agree. May I say one thing, please?
If you have a closing, you can make a closing.
I love my cousin and I hate that it came here. And I wish that it would have been handled differently on both sides. We're going to be angry and we'll probably never speak again. And I'm 100% okay with that. But not one time did I go and tell anyone outside of your auntie and your mother. Nene knows nothing. And I want to know that.
Okay. Do you have a closing then for Ms. Hogue?
No, Your Honor.
All right. And so if there is nothing else from either side, then
You can ignore that, G. She's Miss Ho.
the court will have its decision out within 90 days or less. Again, if either side does not like my decision once it is issued, you will have 30 days to appeal it to the Court of Appeals. And so if there is nothing further, then please have a good day. And I hope the best for both of you all as you are family. All right.
Thank you.
And I'm sorry for your losses.
Thank you. I appreciate it. It's my loss, not hers.
All right.
Thank you.
All right. Bye-bye.
Judge, don't you worry. You don't need to make a decision. Nene's going to find out. Nene's going to fix it. Nene's going to make the decision around here. Okay. Let's go to Eric Johnson. I love this judge. So then we're just going to pop in for a little bit.
Thank you, Your Honor.
Okay.
Counsel.
Thank you, Your Honor. This is Mr. Flores, number 13 on the court's docket.
Thank you.
All right, 23 CR 6513, People versus Flores. Entries?
Daniel Cohen on behalf of the people. Ms. Knowles will be on this case along with me.
And Maddie Curry and Zoe Bernstein from the Public Defender's Office on behalf of Mr. Flores, who does appear in person in custody to my right.
Judge, back off.
All right, so we're here on the
Space. Oh,
victim statements.
Yes, Your Honor, I believe that is why the court set for status today. The people filed a notice to introduce specific statements made by Ms. Alicia Serrano in the event that she does not come to trial, which seems to be, well, I don't want to speak too soon, but in the event that she doesn't come, the people did file this motion. I had an opportunity to respond, and I'm happy to provide any further information or argument to the court should the court require it.
Prosecution?
Your Honor, I know that Mr. DeCecco filed a pretty extensive motion with the court that included the specific statements that were being sought to be introduced, as well as, I believe, providing some of the audio recordings of them, and as well as the legal basis under which we believe they are they can be introduced. So I'm going to rest on Mr. DeCecco's written motion, but I'm happy to answer any questions the court may have.
Yeah. All right, then we'll rule on it tomorrow morning. See everyone tomorrow.
And I do want to let defense and the court know that I'd say it's this point, it's still a possibility that the victim will appear. We're unsure.
Yeah, I'm kind of wait. We'll wait and see what happens.
Yep.
And Your Honor, I did file motions in limine. I apologize, late yesterday. The only additional issue that I did not raise within the motions in limine is, I think, a Rule 16 matter. Your Honor, since our
That wouldn't be a motion in limine.
right, so that's why I'm bringing it up verbally to the court now. Since our pretrial conference date on December 16th, the people have filed 3 additional witness list disclosures to defense. We would ask that the court consider precluding the testimony from each of these witnesses due to the late disclosure of these witness lists. On January 2nd of 2025, Janice Wilcox with the 911 call center was endorsed for the very first time. It's my understanding that the district attorney was provided and provided defense with incorrect information about who took the 911 call on the night of this incident. They've now filed the supplemental endorsement days before trial, endorsing Ms. Wilcox as the 911 caller. It was accompanied with a late MOI, which I guess for the record is a memorandum of information about a phone call they had with Ms. Wilcox, confirming that she was the person who took the 911 call from Ms. Serrano and not Ms. Thompson, as we had been given information over the course of the representation of Mr. Flores for well over a year now. Additionally, Your Honor, a late endorsement, Dustin Snyder was endorsed. I do believe that this is probably more pertinent to the habitual trial, which that's not a bridge we're going to cross. But if Mr. Snyder is not going to testify at this trial at hand, I don't believe that that's an issue. However, the final issue is that Ms. Footloosero, we were just given an updated CV, an opinion letter, and new diagrams. We would ask that Ms. Footloosero not be entitled to testify as to those items, as they were not submitted in accordance with Rule 16. That would be defense's request at this time. And I'm also happy to brief these issues before tomorrow should the court need further argument or legal support.
Well, is Ms. Footloosero a blind expert?
I'm going to have Mr. DeCecco handle this one.
Is she a blind expert?
Yes, she is.
And when did you get the exhibits?
These were filed with the court on December 27th while I was out of town.
That's correct. After we met with her, she provided her standard opinion letter and the diagrams she likes to use.
Right, other than being late, is there what's the harm to the defense?
I suppose the harm is avoiding trial by ambush. There are deadlines for a reason. This is also the 3rd trial setting, and we haven't had this information until now. That would be the prejudice to defense.
But you had her opinion letter, right?
No, those
You
were,
had nothing?
Yeah, the CV.
Prosecution, why are we endorsing things? Why are we providing this opinion letter so late?
Your Honor, all I can say is I took over this case last fall when Mr. Bassiano left, and I didn't have the opinion letter at that point, and Ms. Lucero provided it when we were doing prep.
All right, so I hear no reason. If you're going to be endorsing blind witnesses, you need to be prepared. Everyone here knows what she's going to say, and everyone knows what she is. Your experienced counsel, you know that these diagrams are just the pictures of the throat and where the veins are. If you are unable to, you're telling me you cannot prepare a cross-examination, then I'll entertain a motion to continue.
I think we can prepare cross-examination, Your Honor. We would not like to continue at this time.
And just speaking out loud, I've been hearing a lot of, I just took over this case, not from you, Mr. DeCecco, but in general. And that isn't an excuse for anything. People need to be jumping on these cases earlier and making sure things like this don't happen. If there were any type of harm to the defense that I could come up with, if this was anything other than a blind expert that everybody knows what she's going to say and what these things are, then I very well may be excluding evidence. Just taking over a case and deciding that, and then getting the ducks in a row is not an excuse for this stuff not to have been done previously. Now, what's the story behind
Get him, Judge. Get him.
the 911 call?
I can explain. So the CAD report for the incident in this case only listed one call taker, but there were two 911 calls made, one by the victim, one by the neighbor. And I believe...
So you had one call taker listed as to one call, but it was obvious that there were two calls.
And right, there were two like numbers for the call takers listed, but not her name. So I didn't have Ms. Wilcox's name until I spoke with the call taker listed on the CAD. And she said that was a different call taker.
Is this a witness that you're calling only if the victim doesn't show up, or is this a witness you're calling regardless?
Only if the victim doesn't show up, just to authenticate the 911 call.
And Judge, if I may briefly, I think that exacerbates the prejudice to defense here. It has been apparent since well before the last trial setting here that Ms. Serrano was at best lukewarm about proceeding with this case. That was something Mr. Bassiano and I had extensive discussions about. That's why we were before this court with potential resolutions to this case. And it was very apparent at the last trial setting, which I believe was almost 6 months ago, that Ms. Serrano had no intention of appearing. At least then she was under subpoena and did not appear. And there has been a pending warrant since. So the due diligence is lacking. It was apparent that this person should have been a part of their investigation. It was pretty clear Ms. Serrano was not going to want to testify. And if the people are seeking to introduce these statements through this third party is someone who should have been engaged and contacted months ago.
Well, they're not moving to introduce the statements through this party. This party is simply going to authenticate a call of which you were aware. So the only surprise to you is that they've got a way to get evidence in that you were possibly hoping they couldn't get in. If you have, again, if there is an actual cross-examination that you cannot prepare for someone who is simply authenticating a 911 call, I'll entertain a motion to continue. Otherwise, I'm not going to keep that out. I don't know if the 911 call is coming in.
Savage.
I mean, I don't know if there's a hearsay exception or whatever else, but the motion was to exclude a person whose only role in the case is authenticating a 911 call that they took, a call that is not a surprise to the defense, and I decline to issue that as a sanction. So if you want to, if you're telling me that there's a cross-examination that you cannot prepare for, then I'll entertain a motion to continue.
Understood, Judge. And we, again, are not moving to continue at this time. And I understand the court's made its ruling. I just want to make a record. I do believe that we are getting into some degree of pattern and practice territory here with all of these late endorsements. So I just wanted to make that record.
And did the court receive the link I sent with the 911 call and video? It's through a third-party platform, so I wanted to make sure it came across.
I didn't get it. I mean, I don't know if it's in the 4G. With me, you're better off walking discs over.
Understood.
Yeah, I don't think I've got any. I don't think I've reviewed anything as to.
Would the court like
So I haven't reviewed anything.
discs before tomorrow, or to review first thing?
Al, do you want me reviewing it before we bring a jury up, or do you want me to be prepared for trial before we start? Trick question.
Yeah.
Okay. All right, we'll see everyone tomorrow.
Thank you.
Then the judge is going to yell at you too.
All right, so at this point, we still don't know whether or not we're going forward with the sex assault.
We do not. I will tell the court that we're as close as we've ever been to having her present for court, as far as I understand, but a lot is going to happen in the next happen or not happen in the next 24 hours.
Ms. Curry.
Thank you, Your Honor. This is Mr. Pineda. He is number 39 on the docket.
All right, 24 CR 997, People versus Pineda, entries.
Daniel Cohen on behalf of People for Kate Knowles.
And Maddie Curry on behalf of Mr. Pineda, who does appear on bond in person to my left. Your Honor, we are set for a pretrial conference today. Ms. Knowles and I again touched base about Mr. Pineda's case this morning, and a new offer was just extended. That offer contemplates a dismissal of this case with a guilty plea in 24 CR 6245. I will just put on the record that the offer is to plead guilty to a class 5 burglary charge with an open sentence and a request for a PSI in the new case. Your Honor, given that this offer was extended this morning, Mr. Pineda is interested in the offer and just wants an opportunity to confer with his family and loved ones about whether or not that's in his best interest, and, you know, continue to ask me questions about it, should he have them. My request would be to set for status with a tolling or potentially even a waiver of speedy, either to this Friday or next Monday. I'm available, well, this Friday.
We're set for trial already. We already got a
Exactly.
trial date.
I was going to say 1:30 on Friday would be optimistic, but I think it's safer to set next Monday. That would
Are
be,
you moving to continue the trial? I mean, otherwise there's no reason to toll anything.
Yeah,
we're prepared to do that if the court requires us to do that. I do think that we will resolve this.
Don't put that on me.
I mean,
What, you got a trial date? I've got a trial date.
okay.
I'm happy to give you a trial date. If you're telling me he's thinking about accepting a deal and you want to move to continue the trial and toll speedy, that's your call. That's not me forcing you to do anything.
And I'm apologizing.
Otherwise, let's go to trial. I like trials.
I did not want to, I'm sorry if I communicated that. We're happy to continue the trial. So in contemplation of taking this offer.
Prosecution?
No objection.
All right, Mr. Pineda, this is your motion to continue the trial that is set for the 21st. If you tell me you want your trial on the 21st, I will give you your trial on the 21st. If you're telling me you want to continue it so that you have time to talk to your family and about whether or not you're going to accept this offer, which would result in the dismissal of this charge, the case that we're here today on, then that makes sense to me. I get it, and I'll grant the motion. But it's your motion, and if you move to continue, it is a waiver of speedy trial. As of right now, we would have to give you your trial by March 3rd. Like I said, it's set for January 21st. Do you want to continue the trial so you have time to contemplate this offer?
yeah, I'd be willing to waive my speedy trial.
All right, then I'll grant the motion to continue. We'll vacate the trial that is set for the 21st. What do you want? Where is the other case?
Your Honor, the other case is set at arraignment stage. Let me see when it's next set.
13th.
Oh, it's on the 13th.
So just next week?
Yes, so next Monday. I would just ask to add this.
Do you want both of those continued? Or do you want to, are you gonna have a decision by Monday?
Yeah, that'd be great.
I'm happy to,
People are asking that we maintain that Monday date.
That's a big date if we can get rid of a case. But what are we doing on that date? If it's just an arraignment, we're going to walk in and ask to continue because a joint offer has been given and he needs time to think about it. What's the other case number?
it's 24 CR 6245.
You know, and in the interest of the court's calendar, we are fine continuing both of those dates to a joint disposition date in the near future.
Yeah, I don't see you have any motions filed. I mean, is there a need for y'all to appear on the 13th?
I think the only need was just to get this case resolved while the clock was still ticking.
Okay.
So they'll put it together, and then they'll take the plea, and we won't get to see any trial. However, now that judge has a packed docket on Monday. He has 120 cases, I think, or something on Monday. So I can't wait till Monday. I've just been waiting for Monday to get that judge. I'm going to get the whole thing. I was thinking about members only live streaming the whole docket, but I'm not going to. I mean, I got this close, but I'm not going to because I'm just going to get the good stuff and do it in my stream. Yeah. Don't go back to work, CJ. Tell your boss no. Okay. This next one. Okay, here's what happened. I have 2 clips. And I was going to make a video out of those 2 clips to put out during the day, just like I'm supposed to do. So I tried to do it here. I ran out of time, so I decided I'm going to do this from work. Yeah, it is lazy, but I don't think you understand. A full docket of him. All day long of him yelling at lawyers is great. So I tried to make this at work. But someone came in and interrupted me while I was making it. So there's no camera on, and I talk about that. And then I realized that there's no way I can keep this as a video. So then I stopped talking completely. So don't worry, I'll talk here. But I'm going to just mute the first part because I started the first part and there's this real loud screech. I don't know where it came from. Hi guys, it's Kathy. I hope you're doing well. So I don't know how to turn the camera on and record at the same time. I don't have software on my phone that does exactly what I want. So this is what I'm doing. No camera today, which is a good thing for me. So just a quick video. I'm at work. So if it sounds like I'm underground, I snuck into a back room while my tables are waiting. Fozzie, I did this for you. To make this video. Don't worry. They'll be fine. They'll be fine. Let's just get going.
All right, Mr. Redmond.
So the audio at the beginning is shaky because the jailer people are all like yelling to each other. It settles down. The audio settles down just fine in a second. Bonjour. I know, Lazzie. I do know.
Mr. Redmond.
I'm not Mr. Redmond. I seen he was over there and said that interview. Yeah, that's the one that done it. I was saying that was him.
Your Honor, Mr. Redmond is present in court, sir.
All right. Mr. Redmond, you don't have counsel, is that correct?
I do not need counsel.
All right. And
Honor.
are you ready to has he been offered a plea?
Yes, Judge, they've all been offered a plea
Okay,
before.
that's fine. I just want to make sure. All right, do you want to accept the plea that the district attorney's office has made to you, or do you want to go to trial?
Don't worry, he's there.
I do not wish to accept any kind of.
You're going to have to sit up and talk through the microphone so I can hear you, sir.
Oh, don't worry, I'm getting this trial if I can. Don't worry.
All right, you were saying?
Do not wish to accept any kind of plea offers or deals.
All right, then that's fine.
Thank you.
All right, this matter will be set for trial then, Mr. Redmond. You have a nice day. Thank you.
Thank you for wasting everyone's time too, Your Honor.
Your Honor, you didn't waste my time.
All right, we'll go back to Mr. Santana then and
20 of us murdered this guy, you guys. That's what it counts for.
all right, Johnson State, I am through with Mr. Redmond.
Anyway. Yes, ma'am.
So that was the first guy. The next guy is okay too. We don't get to hear from him too much, but we get to just his crimes. The crimes that happen is the reason why I got the next one. And if you hear this noise, that's my tequila sunrise.
All right, just let him go on
Yeah, you
back.
can let him go.
He can go on back, yes.
Really,
All right,
really.
Mr. Maxwell, if you'll come forward.
And there's my other tequila sunrise. Hi, Bill.
All right. Mr. Santana, if you'd unmute yourself for me, please. There you go. Thank you. Mr. Santana, can you see the court?
Yes, sir.
All right, and can you see, you're gonna need to go to where,
That woman talking in the background. That's the other server. She came in. She started complaining about this woman at the bar hard. And I wish you could have heard it. What she just said is, no, you're ordering shit we don't have. So, yeah, don't worry. She only talks for a second. I wish you could have heard it. I wish it would have been there, but yeah, it'll be over in a sec.
Miss Cameron and Mr.,
I'm gonna get out of the way.
and Mr. Santana, do you see, your attorney, Mr. Maxwell? He's waving at you.
Yes. Yes,
All right. And
Sorry, I told them I was recording, but I think I'm keeping that in there, guys. People already get mad that I talk too much. Wait till they hear the other server.
you see the, two assistant, district attorneys. One's in
Yes,
a
sir.
gray jacket and one's in a blue jacket.
Yes, sir.
Very good. All right, and you can hear us.
Yes, sir.
All right, is there a plea agreement or recommendation in regards to Mr. Santana?
Yes, Your Honor.
And it is.
The offer is that he would enter a plea on count 2 of the indictment and would receive 5 years to serve with the Department of Corrections, and that could run concurrently with his present Department of Corrections sentence.
And you're going to null pros count 1.
Yes, Your Honor.
All right, so the court calls 22R179, the state versus Santana. Mr. Santana, if you'll be kind enough to raise your right hand for me, please. Do you solemnly swear or affirm the testimony you're about to give in this matter is the whole truth and nothing but the truth, so help you God?
I do.
Very good. You can put your hand down now. If you'll give us your name and age.
Tiburcio Santana, age 49.
All right. Are you a United States citizen?
No, sir.
All right. Do you understand that by
This is Georgia, guys. Georgia.
pleading to this charge this morning, it could result in your being deported?
Yes, sir.
All right. And you have talked with him about that, Mr. Maxwell?
I have, Your Honor.
Very good.
I don't think he's worried about being deported only because he's incarcerated now for at least 5 more years.
How much education have you had, sir?
Up to 11th grade.
All right. Can you read and write?
Yes, sir.
Can you hear and understand my questions this morning?
Yes, sir.
Are you suffering from any physical or mental disease here today?
No, sir.
Are you now under the influence of any medications, drugs, alcohol, or narcotics?
No, sir.
You're pleading to the count 2, which is riot in a penal institution. Do you understand that charge?
Yes, sir.
And what is the range of a penalty in regards to that particular charge?
1 to 20.
And do you understand that the range, or that this court could sentence you from 1 to 20 years with the Department of Corrections and require you to pay a fine up to $100,000 as to that charge?
Yes, sir.
And do you understand that you have the right to stand on your not guilty plea in this matter?
Yes, sir.
And do you understand that if you stand on your not guilty plea in this matter, you'd be entitled to a jury trial?
Yes, sir.
And do you understand that at that jury trial, you'd be presumed innocent, and that presumption of innocence would remain with you throughout the jury trial unless a jury were to find you guilty beyond a reasonable doubt?
Yes, sir.
And do you understand that the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And do you understand that at a trial, you'd have certain constitutional rights?
Yes, sir.
And do you understand you'd have the right to confront and cross-examine each witness that the state called to testify?
Yes, sir.
Prison guard.
And do you understand you'd have the right to subpoena your own witnesses to testify in your defense?
Inmates.
Yes, sir.
And do you understand you'd have the right to testify yourself and present evidence in your defense?
Yes, sir.
And do you understand you'd have the right to be free from self-incrimination, meaning that you couldn't be forced to testify?
Yes, sir.
And do you understand you'd have the right to assistance of counsel during trial, meaning that Mr. Maxwell would be present to assist you in the trial of the matter?
Yes, sir.
And do you understand you'd have the right to be present during the whole trial?
Yes, sir.
And do you understand you'd have the right to remain silent at that trial if you so desired?
But not be
Yes, sir.
And do you understand that by pleading guilty, you're waiving your right to a jury trial and these constitutional rights that I have just reviewed with you?
Yes, sir.
And do you have any questions at this point regarding these constitutional rights for either the court or your attorney, Mr. Maxwell?
No, sir.
Mr. Maxwell has been representing you. He's here this morning. Have you had enough time to talk with him about your case?
Yes, sir.
And are you satisfied with the services that he has rendered to you in regards
Yes, sir.
to this case?
Yes, sir.
I know you're confined with the Department of Corrections, but I have to ask this question. This question is so funny. He has to ask it, though. Have you ever been convicted of a felony prior to this case?
Yes, sir.
Then how do you plead to the charge of riot in a penal institution in case number 22R182, guilty or not guilty?
Guilty.
Are you in fact guilty?
Yes, sir.
And did you, on the 7th day of May 2021, here in Telfair County, Georgia, while being lawfully confined in the Telfair State Prison, a penal institution of the state of Georgia, unlawfully commit an act in a violent manner by engaging in a fight with other inmates during which multiple weapons were used and which resulted in injury and death contrary to the laws of the state of Georgia?
Yes, sir.
Is your plea of guilty here today freely and voluntarily given?
Yes, sir.
Has anyone tried to force you or coerce you into entering a plea of guilty here today?
No, sir.
All right, if the state would be kind enough to give the court a factual basis
go.
for the plea.
Yes, Your Honor. On or about the date asserted in the indictment, Mr. Santana was an inmate at Telfair State Prison. He was involved in sort of an altercation between two separate groups there at the prison. Some 12 people were involved in that fight, and Mr. Santana was identified as one of those being involved. One among the 12 did end up losing their life in the course of that sort of melee, but Mr. Santana does not appear to be the main aggressor in that situation. It did not appear to be the one who struck a fatal blow in that altercation. And so that is why we have come up with the offer that we've come up with, the 5 to serve on the right in a penal institution.
All right. Mr. Santana, it's my understanding of the plea agreement that you'll plead guilty to count 2, riot in a penal institution, and upon your guilty plea being entered, the court would not prosecute count 1, the charge of murder. You would receive for your guilty plea 5 years to serve, and that would be concurrent to any sentence that you're presently serving. Do you understand that recommendation?
Yes, sir.
And is that the agreement reached between you and Mr. Maxwell on the one hand and the district attorney's office on the other?
Yes, sir.
Have there been any other promises made to you in return for your plea of guilty?
No, sir.
Had you stood trial in this matter and were convicted, you'd been entitled to an appeal. If you couldn't afford an attorney to represent you in that appeal, this court would appoint you one. Do you understand those rights?
Yes, sir.
And do you understand that by pleading guilty here today, you're giving up your rights to such an appeal?
Yes, sir.
All right. Mr. Santana, I intend to accept the plea of guilty and the recommendation, but I'll give you the right to withdraw your plea and you can proceed to a jury trial. How do you wish to proceed?
With guilty plea.
I'll check it out. I love watching her.
All right, you want to go forward with the guilty plea? All right.
Yes, sir.
The court accepts Mr. Santana's guilty plea, finds that there's a factual basis for the plea, finds that he has freely, voluntarily, and knowingly entered into such plea. As to count 2, the court sentences Mr. Santana to 5 years to serve with the Department of Corrections. Upon his entry of that guilty plea, the court will now prosecute count 1. Mr. Santana, you'd have 30 days from the date that this sentence becomes and that particular sentence as to count 2 would run concurrently with any present sentence that Mr. Santana is serving. Mr. Santana, you'd have 30 days from the date that this this guilty plea is officially entered in which to file an appeal to the guilty plea if you wish. You'd also have the right to file a motion to withdraw your guilty plea if you filed it within this specific term of the Superior Court of Telfair County. Have you been issued a weapons carrying license?
No, sir.
All right. I also need to advise you, oh, I'm sorry.
That was very positive.
Let me see something. Ms. Pitts, let me see something. Okay, that's fine then. Thank you. I need to further advise you that you'd have 4 years from the date that this sentence becomes official in which to file a petition for habeas corpus if you feel your constitutional rights have been violated in any way. Do you understand that?
Yes, sir.
All right, let's let the plea be entered. Do you authorize Mr. Maxwell to enter your plea of guilty in this matter as your
Yes.
lawyer, sir?
Yes, sir.
All right.
He's in jail. That was that Run DMC? In jail without no bail. Was that Run DMC? He's in jail. Might go with the win. It was the Fat Boys.
Please, been entered.
Thank you. Mr. Maxwell, on behalf of Mr. Santana, do you have anything further?
I do not, Your Honor.
Ms. Pitts, on behalf of the state, anything further?
No, Your Honor.
All right, Mr. Santana, as a result of your guilty plea being entered as to count 2, I am now processing count 1 as agreed. And that has been done. Good luck to you, sir. That'll conclude this matter.
Thank you very much, sir.
That was my attempt of making a video here at work. Didn't work well because the camera doesn't work. And I was interrupted. So I'm not going to put this out as a video. I'll show it to you guys during my stream. But I've been thinking about you all at work, just so you know, because I made a video for you. Bye, guys. Have a great day. And I apologize about the battery life, because I know that annoys people when batteries get low during videos. All right, last one, guys. We're on the last one. And of course, it is.
Okay, going to the next.
All right, good. Pick 5. Brady, come on up.
Good morning, Mr. Brady. Good morning. Mr. Brady, you are charged with driving while intoxicated. First offense, it's elevated to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On January 1st, 2025, at approximately 12:33 a.m. at 14239 FM 2920 Tomball, Harris County, Texas, an officer observed a vehicle traveling eastbound with expired registration as of February 2024. A traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and ID'd the defendant by Texas driver's license. The officer observed the defendant to have glassy red eyes, slurred and delayed speech, the odor of alcohol upon the defendant's breath, and the defendant fumble with his wallet and pull out his credit cards when asked for his driver's license. The defendant stated he had 2 glasses of wine 1 hour prior. The officer asked the defendant to step out of the vehicle, and the defendant was unbalanced while stepping out. SFSTs were conducted. 6 out of 6 clues were observed on the HGN test. The defendant was unable to perform the walk-in turn and the one-leg stand. The DIC was read to the defendant at Tomball City Jail, and the defendant consented to a breath specimen. The results were .218 and .208.
Any priority to BIs? Do you mind looking, please?
No criminal history, Judge.
And you ran his license. See if he has a valid license, please. Mr. Brady, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, your bond will be revoked. You will go to jail. Do you understand?
Yes, Your Honor.
If you have a valid Texas driver license, you may continue to drive, but you must maintain liability insurance as well. If you do not have either, you are not allowed to drive. Do you understand? That is also a condition of your bond as well.
Yes, Your Honor.
Tell me, what do you do for a living?
I'm a cook, Your Honor.
Did you want to apply for an appointed lawyer?
Your Honor, I don't have a lawyer. I need the court to appoint one from you.
I need you to qualify though. So what I can do is I can give you an application. I'll take a look. I need to know everything about you. Just put it on the paper. I'll take a look. If you qualify, I'll give you a lawyer. Okay?
Yes, Your Honor.
Please.
His driver's license is eligible.
Great. Okay, we got you. Please.
Right, Judge, next is page 10. Collins, come on up.
Is it Tyren? No.
Yes.
Please. Mr. Collins, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 31st, 2024, at 2:35 p.m., an officer was dispatched to 12600 Dunlap Street, Houston, Harris County, Texas, in reference to a disturbance unknown weapon call. Upon arrival, the officer made contact with the complainant, who stated the defendant is her son and that he assaulted her. The complainant stated she lives in an apartment with her two sons. The complainant stated that a month ago she asked the defendant, her eldest son, to help pay for rent, and the defendant agreed to pay a certain amount. The complainant stated she got tired of asking and told them that she was not renewing her lease. The complainant told the defendant he needed to move out by December 31st. On that day, she arrived at the apartment to turn her keys in and do a walkthrough with the complex manager, the witness. The complainant stated as she was removing the locks from the doors, the defendant pushed her with both hands and punched her in the chest with a fist, causing pain. The witness stated the defendant was acting aggressive and was refusing to leave the apartment. The witness observed the defendant push and punch the complainant.
Any dope or alcohol?
No allegations of drugs or alcohol, Judge.
Do we know what she wants?
Yes, Judge. I spoke to her yesterday and she is requesting no threatening or harassing contact and that he not be able to go near her new residence.
Got it. Okay, Mr. Collins, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your, well, hold on a second. Let me see. It looks like a protective order was issued on the 1st of this month. I would get to know it because if you violate this protective order, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. You violate conditions on a VPO, I can have a hearing to hold you at no bond, zero bond, and I will do it in a heartbeat to protect my community. Do you understand?
Yes, I also had a witness too.
Stop. You will get the opportunity to fight. Now's not the time. I got a bunch of DAs here. I don't want you to say something. You'll get the opportunity. Just now's not the time. I am ordering you as a condition of your bond not to have any threatening or harassing contact with the complaining witness in this case. Understand what is threatening or harassing doesn't matter what you think. I could care less. It's what she perceives. So if I go like this, is that threatening, harassing? It most certainly is. And it can be a basis to revoke your bond. Do you understand?
Yeah.
All right. Tell me, what do you do for a living, Mr. Collins?
I work.
Do you have enough money in that work to hire a lawyer?
No.
Tell me about what you do then.
I work as an HVAC tech.
All right. So what I can do is I can give you an application. I need you to fill it out. Don't just put zeros because I'm going to send it right back to you. I need you to fill it out. Be honest. I'll take a look. And if you qualify, then I'll give you a lawyer. I am going to file conditions that you're not having threatening or harassing contact with mom. It's mom?
Mom and Judge, the protective order says no going within 200 feet of her previous residence. She gave me her new address. So if we
Okay.
could
Do you want to
add-
refile it?
We could. Do you know how to refile?
Put the correct address in the MOA? You want them? Let me just, Then, all right, I'll print it out. We'll just amend it. I need to know, or I'll give it to you. You put the correct address.
Yes, Judge.
So, Mr. Collins, you're not allowed to go where she lives. Do you understand? If you go there, I'm going to revoke your bond. I'm going to put you in jail. You need to understand, if you don't have anyone that's going to pony up $5,000, $10,000 to get you out of jail, you'll be stuck like Chuck in there until this thing is over with. Consider that when you're out there in the free world. I'm not asking for much. Just don't become a danger to our public. Don't violate conditions. That's it. All right, Stephen, do you mind giving an application? Do you mind filing no threatening, harassing contact and no weapons?
All right.
Good morning, Ms. Dela Cruz. Ma'am, you were charged with unlawful carrying of a weapon in a public place. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay, guys, please.
Your Honor, on December 31st at approximately 11:37 p.m., officer was dispatched to a weapons disturbance at 1111 Grove Street Apartment, 1111 Houston, Texas. We informed the officer, the witness informed the officer that she was outside and heard a gunshot and looked to the left and saw defendant, witness's neighbor, waving a gun in the air toward the kids in the playground and towards witness's group. Witness stated that defendant left location and returned yelling and waving the gun in the air and pointing it all around the apartment. We recorded the interaction. Witness recorded the interaction with the defendant pointing the gun and trying to shoot it, but nothing came out at the time. Another witness informed the officer that she heard a shotgun shot, then observed defendant waving gun toward a basketball court and park where there were kids. Defendant then ran into the house. A third witness corroborated both accounts. Witness number 3 also recorded the incident. Defendant was ID'd by eyewitnesses and a mugshot. Defendant was found sitting on her porch and observed the officer.
Strong odor of alcohol.
Observed a strong odor of alcohol.
Okay.
And the officer found a case.
So AB, is that what it says?
Yes, Judge.
Strong odor of alcohol in her breath.
Yes, Your Honor.
So did she actually get a shot off? Did you have,
Judge, the officer found a casing in front of her apartment.
do you have anyone that saw though?
Nobody that physically saw her get the shot off, just they heard the shot and then they saw her waving the gun around after that.
Ms. Dela Cruz, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it and you're not going to like the way that I do it, man. Stop. I don't want you to say anything. I'm just telling you what the expectation is here. I'm going to protect my community at all costs. I don't care what happens, with who it is, what color, small farm animal. I don't care. I'm going to protect my community. You're not to be in possession of any weapons as well.
Yes.
If I find that you have a weapon, likewise, I'm going to revoke your bond, put you in jail, and I'm going to raise the bond. I'm not asking for much. Tell me what you do for a living, ma'am. Do you have the ability to hire a lawyer?
Right now,
Do you have the ability to hire a lawyer?
well, somewhat if I need to, but I wanted to ask for a court appointed at first.
So let's do this. I can give you an application to fill out. I'll take a look, and if you qualify, I'll provide you a lawyer. But I need to know everything about you and just fill it out honestly. You don't have to tell me. Just put it on there. Well, I need numbers though. Give me numbers. I'll take a look, and if you qualify, I'll provide you a lawyer. You're gonna meet with Felicia for your bond conditions. No, Felicia for your bond conditions. No alcohol. Do you understand, ma'am? No weapons. That's all I'm asking you to do, and don't pick up a new case. Okay, Stephen, please. You ready? Come up, Ms. Strong.
Andrew, come on up.
How are you?
I'm good. How are
Great
you
to see you. What's new?
Happy New Year.
Happy New Year.
Thank you.
Please tell me, Rabbi. Good morning, Ms. Landrum. Ma'am, you are charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Yes, Judge. Okay. Hi, Alex. On December 21st, 2024, the officer was dispatched to a major accident on East Freeway in Harris County, Texas. The officer made contact with the complainant. The complainant stated he was traveling in lane 2 out of 4, observed his rearview mirror, the defendant's vehicle traveling at a high rate of speed, following closely with a motorcycle also traveling at a high rate of speed. The complainant stated the defendant was racing with the motorcycle. The defendant was mimicking the motorcycle's lane changes in speed. And when the defendant entered lane 1, the defendant began to lose control and her front bumper collided with the complainant's front right, causing him to lose control and crash into another motor vehicle. A total of 4 motor vehicles were involved in the collision. All vehicles were towed and the damage for each vehicle was over approximately $1,000. The officer made contact with the defendant, who identified herself as the driver of the vehicle.
What does high rate of speed mean?
Let me see if the officer specified.
I mean, I'm going to find probable cause, but I'm curious. I mean, if she's going just while he's doing that, Miss Landrum, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive like this again. And if I find that you're driving like this or you pick up a new case, I will take your ability to drive away. And I'm going to tell you, living in a city as big as Houston without the ability to drive blows. It's awful. Try living without driving. It's terrible. So just don't, please.
Your Honor, the speed's not specified in the OR.
I mean, I think that there's enough to go now for probable cause. Just be careful. You've got a great lawyer. She will take care of you. You must listen to her. Because you have a lawyer, I will waive your appearance, but you have to stay in touch with her. If she tells me she can't get a hold of you because you're playing games, I'm going to issue a warrant for your arrest. Don't pick up a new case and not on 610. All right. We're going to craft bond condition for you to sign. Once you sign them, after that, you'll be free to go. Okay? All right. Thanks, Mr. Jones. Just no reckless driving, racing, donuts, street takeovers, and the like that.
Thank you.
Okay.
Thank you.
Please.
This way.
No driving like Batman.
All right, Judge, next is case 12.
Oh, thank
Diaz,
you.
come on up.
So can you file those conditions? Do you
Yes,
want?
To the stairs, Donald, to the stairs.
You are Diaz Jimenez, correct?
Yes, Your Honor.
Mr. Diaz Jimenez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 1st, 2025, the officer observed a vehicle on the 19700 block of US Freeway 59 make a last-minute lane change and cross a solid white line. Once in the lane, the vehicle failed to maintain a single lane and touched the white line multiple times. When the vehicle came to a red light, the vehicle stopped much slower than prudent and slowly inched up to the stop line. Once at the stop line, the vehicle proceeded past the stop line with the entire vehicle nearly past the line and in the intersection. The vehicle then accelerated through the red light, running the red light, and a traffic stop was then initiated. The vehicle failed to maintain a single lane multiple times before stopping, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have an odor of an alcoholic beverage, slurred speech, and red, glossy, bloodshot eyes. The officer asked if the defendant had any alcohol to drink, and the defendant became belligerent and refused to answer. The officer observed a strong odor of an alcoholic beverage, and the defendant agreed to perform standard field sobriety tests, but walked away and refused. Based on training experience, the officer believed they lost the use of mental faculties and physical faculties, and the DICs were read. However, the defendant refused breath specimens. A blood search warrant was signed and executed.
Got it. Any priority to be honest? Can you check, please?
There was a prior in 2017, Your Honor.
Out of Oregon, Judge.
Okay. Mr. Diaz, I'm going to find that there's probable cause to go forward with the case. I am now can you run his license, please?
Yes, Judge.
I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to put you in jail by revoking your bond and raising it. Do you understand?
Yes, Your Honor. We don't have a license on file, Your Honor.
If you do not have a license, you are not allowed to drive, and I'll have you sign an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to save 50 children. If you don't have a license
and a guardian interlock on your car, you are not allowed to drive. Do you understand?
Yes, I understand that.
You will be randomly tested also to prove, so that we know that you're not consuming any kind of other substances as well. Tell me, Mr. Diaz-Jimenez, do you have the ability to hire a lawyer? Okay, if you ever have any issues, come back and we can talk about giving you an application for an appointed lawyer. But I'm absolutely serious when I'm telling you I'm going to protect my public at all costs. Every single day, there's a death in Harris County due to alcohol. You understand? All right, I'm gonna have you come up here, swear to us. I'll get you to Victoria to sign a reset. You'll get with Maddie for your bond conditions. Then after that, you'll be free to go. Please.
Bossie's never
All right,
satisfied,
Judge, next is
ever.
page 12, Duran, come on up.
Just go ahead, take your seat, please. We'll wait for your lawyer to get here. All right.
All right, Judge. Page 2, Angel. Erica Angel. Judge, this one bonded out.
Sir, step over this way and I'll come to this. And the guy will turn this to a call.
Say it again.
Page 2, Angel.
Good morning, Miss Angel. Ma'am, you are charged with theft of service. You're facing up to 6 months in jail and or a $2,000 fine. Do you have a lawyer today, ma'am? Let's do this. I'll provide you one today. Let me have you take a seat in the jury box and we'll see where we go. Your case is extremely old and I don't know where we're going to go from here. So let's do this. I'm going to have you provide your lawyer today. We'll have you talk to them and we'll go from there. Just take a seat for me in the jury box, please. Thanks.
Should we have 2 more that the attorneys are not doing?
Okay, let's wait. Any THAs? Right, but it's not a second though.
Oh, that's fine.
It's not a second.
It is.
It is a second, but it's being plugged out.
Right, it was charged as a second to a first.
All right. Good morning, Ms. Smith. Ma'am, you were charged with driving while intoxicated. Second offense, you were facing up to a year in jail and or a $4,000 fine. Looks like you guys have worked the deal of a century because they're going to reduce it to a first, which I don't know if you realize this, but this bypasses the mandatory 5 minimum in jail that you would normally be doing. So understand that this is a big one, but you still have to understand 1 and 1 are 2, 2 and 1 make 3. What happens on the next one? You were looking at a felony charge, a minimum of 2 years in prison, a maximum of 10 years in prison. All officers will presumably do, look at your record. If you get pulled over, they smell alcohol, boom, right back in. If I were you, even if you had a sip of alcohol, I would never get into a car because you were taking a humongous risk. Do you understand, man?
Yes, sir.
It is a very, very serious business. The agreement that you've worked out is they're offering you 180 days in jail to be probated for 15 months. For you to complete this probation successfully, you must do a repeat offender DWI education class. You must do 2 victim impact panels. You must also do a TRAS, which is an evaluation to see what other conditions you may need. If they assess further conditions, you must fulfill those. If you don't, then into jail you go. If you consume alcohol while you're on this probation, if you pick up a new case, if you drive when you're not supposed to, your bond, or we're going to issue a warrant for your arrest, put you in jail. I'm going to bring you back out here. We're going to have a hearing to see whether you violated the probation, and you're looking at 180 days in jail. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You could be deported, excluded from the country, denied naturalization. Under federal law, you give up the right to appeal. Once you plead guilty, there's no turning back. It will go on your record. It's going to stay there for the rest of your life. Is this what you want to do, man? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. You must also have complete substance abuse treatment, no drugs, no alcohol. You must maintain a guardian interlock and no breath test refusal, meaning that if you're pulled over in a car and an officer asks you to submit to a breath test, you must do it. If you don't, you're in violation of the probation. Alex, can you see if she has a license, please?
Yes, Judge. It's eligible, Your Honor.
No. Okay, you can reduce your fees to the minimum, and we'll waive the court costs and all that. Okay. If you ever have any problems, come back and talk to us. But the worst possible thing that you can do is just take off, because that it assures a warrant will be issued. The other thing is, don't use alcohol. Do you understand? Okay, ma'am. How do you put, she said guilty, right? Okay, all right. Good luck, man. We'll have you see probation officer. All right, thanks. No, she needs a guardian. Good morning, Mr. Duran. Mr. Duran, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Officers were working in undercover capacity, and they advised, they observed a black Jeep engage in a rolling drag race with a yellow Corvette, unknown license plate. Rolling drag races when two or more vehicles align their vehicles from their moving position while traveling side by side on the public roadway. Vehicles then simultaneously accelerate forward at a high rate of speed, attempting to outdistance and outgain each other in a competition of speed. The black Jeep and the yellow Corvette were heading west on the highway at 40 miles per hour.
A Jeep versus a Corvette?
Right.
He was in the Jeep, Your Honor. He was in the Jeep.
And accelerated at a high rate of speed of 90 in a 65 miles per hour zone.
There versus a tortoise.
They maintain visual on the vehicle, observing it exit the highway and enter into the parking lot of a Buc-ee's. They approach the driver of the Jeep. The defendant here stated he knew why he was in the parking lot and he was just trying to have fun.
Right. Your Honor, in the DIMS report, the officer does give the definition of what a roll race, what a drag race is. However, just after that, when he closes the the caption of where the definition is, he never says that he ever witnessed my client and the Corvette line up side by side and accelerate from a point side by side in order to outdistance the other vehicle.
Didn't you say that they like kind of slowed to some kind of like next to each other and then they flew out? I thought I heard that.
Yes, because as the DIMS is written, the officer says he observed the black Jeep, the defendant's vehicle, engaged in that rolling drag race. Then he goes on to define what he meant by that. And that's when he said that they slowed and they went side by side and they accelerated.
I think it's a poorly written DIMS, in my opinion. I
Sounded perfectly on point to me, sir.
think it would have been better had he
Well, but
said,
I guess he's trying to explain to us, hey, what this is, because not many people may know, but I saw them engage in this.
Yes, sir.
Right.
And this did just happen 3 days ago, so we're gonna wait for the offense.
we are still
report.
waiting for the full offense.
Nevertheless,
Right.
that's what happened is they kind of slow down and then they take off, right?
Yes, sir.
Yes, Judge.
Okay, do we have the co-defendant? No?
There was, he was the only one.
All right. Mr. Duran, I'm going to find that there's probable cause to go forward with the case. Have you guys run his license to see if he has a valid Texas driver license?
All right.
Your Honor.
Okay,
Not have one required.
no more. 610 is not the place to do this, and I'm making that a condition of your bond. There are proper places in Houston, but not on our freeways. Do you understand?
Yes, sir.
I'm making that a condition of your bond. If I find that you're doing it again, the first thing I'm going to do is I'm going to put you in jail. The next thing I'm going to take your ability to drive away. Living in this city without the ability to drive sucks. All right, come on, no more. You understand? You've got a great lawyer. Listen to Mr. Stoll. He'll take care of you. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Stoll and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you, you pick up a new case, I'm going to end up revoking your bond. All right, guys, please. So he can't leave until he signs conditions and then he can get, can you file,
Still no reckless, no racing, those type of laws. Yes, Judge.
et cetera? Yeah.
Raven Landry?
Judge, Mr. Evans, has he approached you yet?
No, you mean Colin?
Yes. He asked for a record. I'm not sure why, but I'm ready whenever you guys are ready.
Okay. Who on? Mona?
Eric Castillo.
What's the last name?
Castillo.
Hey, did you gonna put someone on the record? Are we doing the plea or no? Okay. Oh, did you get what you?
It's not there. Sure. But there, it's heat. It's still lawful. So 2 settings ago, you asked the state to subpoena someone to the sheriff's office.
Are we on the record yet, Judge?
Yeah, let's go on the record. All right, we're going on the record. Please do not speak. If you want to speak, go outside. We are on the record. Today's date is January 8th, 2025. It's approximately 10:01 in the morning. Wednesday, January 8th. Guys, if you would be so kind, please identify yourselves for purposes of the record.
Kelsey Siegler for the state. Mackenzie Watson for the state.
Colin Evans for the defense.
And I have a Miss Castillo is on the docket. The case is 228 days old. I'm going to allow you to go, Mr. Evans, please.
So Judge, I substituted in on this case several months ago. Her previous lawyer had not done much work, but I immediately requested discovery. I have issued a subpoena in this case for personnel records for a Deputy Joel Martinez, who is the arresting officer. I was provided with a Brady disclosure and some follow-up documents on several suspensions that he has had. One of the suspensions came from failure to perform duty, which according to the department policies, the failure to perform a duty is an employee who may be deemed negligent or incompetent and fails to assume responsibility or exercise diligence, intelligence, and interest in the discharge of duties. We've got other suspensions for failing to write reports on time. Basically just a pattern of conduct from this officer. I want his personnel file to see if there's other issues that he's had that may not have risen to the level of a suspension according to the sheriff's office policies. I have found in other cases where.
How do you have what you have now?
The state has provided that. The district attorney's office. The sheriff's office has not provided me with the records of the subpoena.
Do you know if they are in possession of any other records?
It's my understanding that yes, they are, but they're working on getting it together.
Do you have an idea of when? Have they reached out to you to let you know? Have you reached out to them? State. What do you know?
So Morgan did her due diligence. We've reached out to Alma Martinez, who's in charge of all disclosures at the office. My understanding is once we do that, and then she says there's nothing else, there's not really anything else we could do. We did show or share all of the disclosures that we do have, all the documents. And further with the subpoena issues, we're still.
We did subpoena her to come today, right?
It was still in progress as of January 6th, the subpoena.
We weren't quite sure who to subpoena from my conversation with Morgan, because we've been in contact with the paralegal from the Harris County Sheriff's Office. And we have asked who we should subpoena in this case. And
Who's in charge of, who's the custodian of personnel files?
And that's something that we're still trying.
Yeah, we don't know who that person is.
And if I may, Judge, at the last setting, you asked the prosecutor to subpoena someone from the sheriff's office legal department.
And she was in the process of doing that subpoena on the 6th. So was that Monday? Yeah.
The only thing I can tell you is that if you want to set this case for trial, set it for trial. And if you don't get what you asked for, then hey, but I don't know. We've gone round and round with them. I mean, there's got to be another file, I would imagine, right? That's
Right, Your Honor, but all that we can do is really reach out to Alma Martinez, and then if she doesn't have anything, then
who's this person?
she just works with the office. She's like in charge of all the disclosure databases and tells us if there's other.
She works with the Harris County Sheriff's Office?
No, with the DA's office.
The DA's office. Okay, so do you want to find out who the proper person to subpoena is, and we can try to find and get them here?
I've subpoenaed the sheriff's office, the custodian of records, for these records that I'm looking for.
Did you put like a date certain for them to be here?
December 19th.
To be here?
Show up. They're still under the subpoena. And you asked the state to get.
To our knowledge, when I'm looking at the subpoena sent out, it just says to contact defense counsel. It does not actually ask for anything specific to be sent to him. So maybe that's why no action has been taken on the
I
subpoena
think
yet.
maybe you're not looking at the attachment.
Show me the subpoena that you have, Colin. Or is it uploaded in the system here?
Should
But I
be.
can.
Not seeing any attachment. Oh, I see it.
I will say we've since subpoenaed.
So I don't think that this is, Colin, the subpoena that you did, you put custodian of records, employee unknown. So they're going to be like, oh, if you put someone's name on it, we got to find out who it is. I have no idea. But if you put someone's name on there, whoever the custodian is.
I think that's what the clerk's office put on the subpoena that they generate. And then on my attachment, there's
got to be a name to attach to it so that we can hold someone accountable. I don't know. I'm
Sheriff, they've got multiple people, from what I understand, that handle records with their entire department. And so they can designate who should be doing taken care of.
How am I gonna do a show cause on, you know what I mean? I need a name so I can do a show cause. So let's do this. I'll set you a week or a couple days to next week. Can you try to look into whoever the custodian of records is for that?
I've been trying, Judge. They've not returned the call. My paralegal called multiple times.
Then just set up a trial. And if they're not producing the records that you say that exist, then we'll handle it in trial.
Okay. I need to discuss that with my client, but
And we have two offers on there, and again, just for the record, we'll say the state did all that we.
He can't do anything with, you need to make an informed decision. You can't do that until you have everything in.
Right, yes, Your Honor, I'll just say for the record that for the state that we did all that we could. This seems like it's a sheriff's issue, not to put blame on them, but we did all that we were supposed to do. So we're trying to get the information, we share what we have.
Person to subpoena. If they don't show up, then I'll have a show cause hearing. I have no problems doing that, but who do I show cause now?
fair enough, Judge.
Show me, I'll do it. I have no problems.
To me, this is a 30-minute issue at this point. You know how long the case is. So,
I'm not holding it against you,
right, and again, I stepped in, history in here,
but I need to know who. And if they don't comply, then we'll show cause them here.
but it can help me
Yeah,
figure out who it is because the sheriff's office isn't calling us back.
we will keep
So,
defense informed on any further communications that we have.
because I will get a subpoena out today.
Who do we reach out to? Let me think about it as well. Okay, and then let's set it for early next week. Or you need at least 10 days or the 14th for the subpoena to go out. But if you can get a name attached to it, and I'll reach out to my staff as well to see, if they have any ideas as well as to who.
Okay.
Okay,
All right.
all right, of course.
Council will recess.
Hi, Will.
Hey, Judge, how are you?
Saw that you signed on.
Yes, I was approaching to get the
Great.
motion filed or signed.
I signed it already for you.
Okay,
Um,
I'm trying to get it on docket for tomorrow.
is Amy here? We can talk about it now. You want to?
Sure, yeah.
If are you requesting a bond?
Yes.
Of course, I can't do anything if I was to grant one without him being here. So we can talk about it now and then go from there. Do you know who's here?
Yes, I do. Dave specifically wanted to come up for this one. I will say just now, since we're talking about the bond, the demanding jurisdiction did say that they're trying to pick him up tomorrow. I know Dave will probably go into more stuff, but
They're picking them up tomorrow.
that's their plan. They've made arrangements.
So, well,
We probably shouldn't put him on docket tomorrow.
right. So here's the deal. We have so many people here from Louisiana. It's ridiculous. So we have buses literally coming once to, if not twice a week for people, usually on Tuesdays and another day. So when we have people going back to Louisiana, they're usually here for no more than 3 days after they waive.
Okay.
So
Okay, so it shouldn't.
the problem is that depending on what happens in Louisiana, if they hold them there for a while, you need to be careful because then Harris County may revoke the bond here for whatever cases he has, and then the reverse exact situation happens there. So, yeah, well, that's what happens with these fugitive cases. It's always messy. So just whoever's representing him upstairs, is it you?
Yeah, that's why I signed on to the case down here, because I have him upstairs.
So I don't know how, I'm just telling you, be wary.
Okay.
Be wary of that. So,
Well, I'll hold off on putting him on docket.
if it doesn't
So
come
maybe-
tomorrow, then we'll,
Maybe you want to put him on the 10th? Is that this?
Friday.
If they don't come, then we can talk about bond then?
what do you think?
How confident are we that they're coming tomorrow?
They
Because
just,
if it's like sometime this week, I won't put them on Friday either.
the sergeant working at the transportation just told me that they're planning to transfer him tomorrow, weather permitting.
They're permitting.
Yeah.
It's supposed to be awful weather tomorrow.
What?
It's supposed to be awful weather.
What are you talking about?
It's rain. Cold.
What? With this cold?
Yeah, all day long. Rain.
Is it gonna snow?
No, there's a line. So North Texas, some parts of the hill country, lots of snow, but down here, just wet, cold.
Jay says he'll be up in 10 minutes too, so. Chill with him.
Yeah, I'll come back.
Justin,
It's John.
always a pleasure. How are you,
The
man?
pleasure is mine. I had Mr. Acevedo, he's present, and we had
Tell
a
me.
talk, we had a talk this morning.
All right, guys, we made it to the end. Thank you so much for coming out today. I want snow too, Monica. Just want snow. More snow. We got snow, just not enough snow. All right. I set this up so that it'll automatically redirect to the OJ trial. So go ahead and, click cancel out of it if you don't want to watch the OJ trial. But it's automatically going to go there. Up. There's a link for you to click. Rebecca, good luck. Bye, Clea. Thank you. Chat was a little weird today, but that's fine. I like the cartoons. Aw, poor Fozzie. Alright, guys. It should automatically redirect you. If not, I put the link in Discord. Thanks, guys. See you in 2 seconds.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray.